In today's story, the city of Myrtle Beach redeems itself. This is from the county of Horry County, South Carolina, where Myrtle Beach is based, and it is the story of Jimmy Richardson, solicitor for the 15th Judicial Circuit, that is, the lawyer for the government, versus $20,701 of used currency. So this is a civil asset forfeiture case. In this case, the court finds the civil asset forfeiture to not be proper, not be constitutional. So whereas Myrtle Beach violated one person's rights by storming into their house and shooting them, the Myrtle Beach has somewhat redeemed itself because the county that Myrtle Beach is in has found a civil asset forfeiture to be unconstitutional. So we're going to read this decision and try to say some nice things about the Myrtle Beach area for a change. So let's get started with this. This matter comes before the court pursuant to the above-captioned forfeiture action, in which the state requests the court approve forfeiture of money seized by agents. This court finds that South Carolina's forfeiture statutes violate the prohibition on excessive fines found in the 8th Amendment to the Constitution and Article 1, Section 15 of the South Carolina Constitution. Furthermore, this court finds that South Carolina Code sections violate due process under the 15th and 14th Amendments to the Constitution and Article 1, Section 3 of the South Carolina Constitution because they place the burden on the property owner to prove their innocence, unconstitutionally incentivizes forfeiture officials to prosecute forfeiture actions, and they do not mandate judicial review or judicial authorization prior to or subsequent to the seizure. So a court has found civil asset forfeiture to be a violation of due process. That is a positive change. I think we can agree on that. The complaint in this action alleges that agents within the 15th Circuit's Drug Enforcement Unit, which, let's take note, is the exact same drug enforcement unit that was involved in that shooting where they bust into the guy's home, the exact same drug enforcement unit, so that's a thing to take note of, made 3 controlled buys of cocaine from defendant Green. The agents arrested defendant Green and charged him with 2 counts of distribution of cocaine. Agents then executed a search warrant on defendant Green's residence located in Myrtle Beach, same city, discovering a backpack containing 132 grams of a substance. 32 grams of white powdery substance, 319 grams of green leafy substance, and 27 morphine tablets. Agents also seized $19,800 located in a closet and $971 that was on defendant's person at the time of the arrest. He has more money on his person than I've ever had on my person, I think, ever. On November the 10th, 2017, plaintiff filed a complaint in the matter requesting the court approve the forfeiture of the monies. The parties have stipulated pursuant to South Carolina Code in the forfeiture proceeding received 75% of all the funds in excess of $1,000. The prosecuting agency receives 25% of all the funds in excess of $1,000, and 5% of all the funds in excess of $1,000 are remitted to the state treasury. So a little bit of financial incentive here to seize the money, right? So, you know, the police get 75% of the money, the prosecutor receives 20% of the money, and the state gets 5% of the money. So a little bit of corrupt motivations, perhaps, one might argue, right? And the first $1,000 is retained by the law enforcement agencies. Okay, noted. All forfeited funds are maintained in a separate account by each agency and can be drawn on and only used by that agency. Okay. Well, I don't know why we want the 15th DEU to have more money, because they use their money to, conduct illegal raids and shoot people in their own homes. So, but sure, let's give them more money. That sounds like a good thing. This court finds that the South Carolina sections are unconstitutional because they violate the prohibitions on excessive fines. They violate due process, and they violate due process, and they violate due process. And the law does not provide for judicial review. Okay, noted. This court finds South Carolina's forfeiture statutes violate both federal and South Carolina constitutional protections against excessive fines by permitting the government to seize unlimited amounts of cash and other property without regard to proportionality of the crime. Indeed, they allow the government to seize unlimited amounts of property when no crime has been committed, without criminal conviction and without proof of crime has been committed beyond determination of proof beyond probable cause. For example, South Carolina's forfeiture statutes would allow law enforcement to seize millions of dollars in assets from an individual where the maximum fine authorized by law is minimal or where no crime has been committed at all. This unfettered authorization to seize unlimited amounts of property from citizens without regard to proportionality, indeed without evidence proving the individual committed any offense, compels this court to find the statutory scheme is unconstitutional and must be invalidated. Yes, you don't have the right to seize unlimited monies just for the hell of it. Amazing. Wow. Deep concepts. Someone taking the 8th Amendment seriously. Great. This court finds the requirement under the forfeiture statute that property owners prove their innocence, placing the burden of proof on the property owner, violates due process. Although in some cases the affirmative defense rules pronounced by the United States Supreme Court permit burden of proof to be placed on a defendant in a criminal case, this deals with affirmative defenses at law. When you are arguing, for example, justification in a criminal case, some states require you to prove that. Usually it's only by preponderance of evidence, but there are affirmative defense rules. So sometimes the defendant has the burden to prove certain things. That's what they're talking about there. But these rules only apply if the government first proves some wrongful act by a defendant. Right. So in affirmative defenses, even if you have an obligation to prove something, the state first has to prove the underlying predicate beyond reasonable doubt. Absolutely true. Because South Carolina forfeiture statute does not require meaningful proof of any wrongful act by defendant, they unconstitutionally shift the burden of proof to defendants, who in some cases are not even charged with any crime. Yeah. This court finds the South Carolina forfeiture process violates the 5th and 14th Amendments of the Constitution and Article 1, Section 3 of the South Carolina Constitution by failing to provide meaningful protections for due process rights of defendants, in that they place the burden of proof on property owners and allow the state to seize and withhold money or other property when the defendant has not been convicted of a crime, when the defendant has not even been charged with a crime, or where the government has not provided any meaningful evidence that's connected to a crime. I tend to agree with the court here. Because forfeiture programs in South Carolina are self-funding, they violate due process in that they create an institutional incentive for forfeiture program officials to vigorously pursue forfeitures, even where there would be no basis for forfeiture and where leniency would be more appropriate. Yes, you have an unconstitutional incentive because you get to keep the money. So you have an incentive to bring as much as you can. So this is not proper. I agree with the court. Enforcement personnel are responsible for conducting investigations following a seizure, including verifying whether the seizure was justified and determining whether to return property, demand the full amount of money or property, or negotiate settlement. The very existence of forfeiture programs depends on the maintenance of income generated by the programs. A budget for forfeiture programs and expenditures who benefit financially are necessarily tied to the amount of revenue generated from the program. Consequently, forfeiture officials, including law enforcement officers, assistant solicitors, that is government attorneys, and outside counsel retained by prosecution to prosecute forfeiture actions, are affected by the desire to generate as much money as possible. Corrupt motives. Forfeiture programs in South Carolina have an unconstitutional incentive to prosecute cases because, in practice, these programs set their own budget and can spend forfeiture funds in any amount on any item they choose, including recurring expenses, without meaningful oversight. Therefore, there's a realistic possibility that forfeitures of officials' judgment will be distorted by the prospect of institutional gain. Yeah, what do you think, guys? Is it possible that forfeiture officials' judgment might be motivated by the fact that they get to keep the money they generate? I think that is possible, yes. I think there might be some possibility, yes. I agree. Because the revenues generated by the programs are used to pay the expenses, to justify the salaries of the employees, and to maintain a level of discretionary spending that would not otherwise be available, enforcement personnel have an institutional incentive to vigorously pursue financial forfeitures regardless of the merits. Yep. A full 75% of all the forfeiture income is retained by the law enforcement agency that seized the property, while 20% of the forfeiture income is retained by the state solicitor's office, which is the state attorney. The requirement that the expenditures be related to drug enforcement activity in the case of law enforcement agencies or to prosecute drug offenses in the case of the solicitor has no meaningful oversight, results in discretionary spending on items that most likely would not have been approved by the legislature. They get to set their own budget. That's in no way concerning, right? Includes recurring expenses from year to year and ensures forfeiture programs in each agency are self-funding. Wow. The amount and nature of discretionary spending determined by officials in each agency is necessarily based on the forfeiture accomplished by the agency in each year. Yes, you get to fund your own budget to unlimited amounts. It's only limited by your own imagination and your own willingness to prosecute. That's in no way corrupt or suspect in any way. Am I right? Lord have mercy, man. Forfeiture officials in each agency are thus permitted to approve spending over and above appropriations approved by the legislature. We don't need those pesky appropriations. We don't need the legislature to do it. We fund ourselves. Outstanding. With these facts, there can be a realistic possibility that the judgment will be distorted. I would tend to think so, yes. Facts that demonstrate an unconstitutional incentive to prosecute forfeiture cases under South Carolina's scheme include forfeiture revenues in each agency are directed to a special designated revenue fund. These funds are used to pay expenses directly associated with the program. These funds are used to pay discretionary items that would otherwise be unavailable for law enforcement. The funds are used to paying recurring expenses, creating secondary budget within each agency that's not subject to legislative approval. We don't need the pesky legislature. We get our own budget from just seizing money from people. That's great. The existence of forfeiture programs in each entity depends on the revenue generated by the forfeitures. Forfeiture revenue is used to justify the salary of the forfeiture officials. Declines in forfeiture revenue may require the elimination of positions, so your job is at stake. Better get those monies, right? Declines in forfeiture revenue require the elimination of discretionary spending, and in practice, officials involved control how forfeiture income is budgeted and spent with little to no oversight by the legislature. That is in no way suspicious, yeah. This court finds the South Carolina forfeiture program violates the Constitution in that they unconstitutionally incentivize the forfeiture. I tend to agree. Under South Carolina law, the seizing agency is required to file a forfeiture action within a reasonable time. The statute does not define reasonable time. The law permits a seizure without a warrant if the seizure is made incident to arrest or probable cause believes to exist that the property was involved in a violation of law. The statute does not have a provision for any type of pre-seizure or post-seizure hearing to determine if probable cause exists. We don't need a hearing. We don't need any judicial determination, right? In practice, many seizures under South Carolina forfeiture laws are not followed by following a forfeiture action, leaving many defendants with the choice of retaining an attorney to file a civil action. Yeah, the government doesn't actually bother filing a forfeiture action at all. They don't even bother with it because they're under no pressure. So it's up to you to sue the government because they're not going to file their own action. They're just going to keep the money, and they invite you to sue them if you want. That sounds totally fair, yeah. The United States Supreme Court has said our precedents establish a general rule that individuals must receive notice and opportunity to be heard before the government deprives them of property. Sounds like a good rule. While the United States Supreme Court has recognized that under limited circumstances a pre-seizure hearing may not be required, the court has never held that state may dispense with the hearing completely. Yes, the government has to have a hearing. Whether it's pre or post is subject to debate depending on the circumstances, but they have to have a hearing. The South Carolina statute does permit a property owner to file a civil action to obtain return of property, but this ignores the fact the government is seizing and keeping property without any judicial determination of the right of the government to keep the property. Yeah, they just hold it indefinitely. Due process cannot mean the state has the right to determine when they wish to afford a person a hearing. No citizen in a free nation should have their property seized without a hearing and be at the mercy of the agency seizing the property to determine when they have the hearing. Yeah, the agency that is keeping your property has the right to determine when you have a hearing to determine if they have the right to keep your property. That seems like a conflict. Yes, I tend to agree with the court. Due process demands more than this. I agree as well. The court finds South Carolina forfeiture statutes violate the Constitution's prohibition on excessive fines. Further, this court finds that the South Carolina Code violates due process under the relevant provisions of law because they place the burden on the property owner to prove their innocence, unconstitutionally incentivize forfeiture, and they do not mandate judicial review. And it is so ordered, the Honorable Stephen John, Chief Administrative Judge of the Court of General Sessions of the 15th Judicial Circuit of Conway, South Carolina. So, this is a case of redemption for Myrtle Beach. Myrtle Beach attempted to do bad things. The exact same drug unit that attempted to do bad things in the prior case has attempted to do bad things here. But here, a court has found, no, you don't get to do bad things. And so, at least the police are being held to some account. So maybe, just maybe, if fate is kind, the police will learn the lesson and will stop interfering with our rights. And if that day ever comes, we will be here to cover it. So I think we all wait for that day. And I am thrilled that the court found that there was a lack of due process here because based on the facts, it's pretty clear there was, and this cannot be allowed to continue. So we will see what happens next as this case goes through many rounds of appeals because the state is extremely well incentivized to not allow this decision to stand. So I have no doubt in my mind this will be appealed and appealed and appealed. And maybe it will become a U.S. Supreme Court case someday, and it will be the basis of overturning civil asset forfeiture. We can only hope that that day may come. So we'll see what happens in 5 years, I guess. So let's keep going with this. But that's all we have for now. Yeah, Karush points out that the government in Myrtle Beach hasn't redeemed itself because it's the court that has to hold them liable. Yeah, maybe I should have phrased that differently. But, I'm stuck with the way I phrased that. So your point of criticism is noted. I kind of wish I had said that differently now. Oh, well.